everyone, and welcome back to our weekly webinar series. Over to Anil, sir.
Thank you, Ankit. I welcome all of you to this 121st episode of AAA Weekly Webinar Series. Today's webinar is in continuation to our effort as we see present scenario in this profession. Most of the lawyers, most of the insolvency professionals, they are occupied in pursuing their transactional applications, avoidance transaction applications, or you can call it COFE transaction applications. The NCLT benches have started taking up these applications. There are many orders available. There are many transactions which have been held as avoidance transactions, and there are many applications which have been dismissed. Out of all this, we thought that we should learn some lessons, and we should also try to see what are the precautions and what are the cautions that we need to take while preparing an application under avoidance transactions application. In our 120th episode, we discussed about section 43, preferential transaction. And we discussed about all various learnings that we have seen so far. However, because of the paucity of time, we could not attend to the various case laws. Even today, we would like to start with section 45, which is the undervalued transactions, read with section 49, because that's very, very important. Because most of the transactions which are now being conducted, because of the paucity of time with the NCLT, because of the capacity problem with the NCLT, the applications are getting admitted little later. So if the applications are getting admitted later, so the period, that is the look back period, is normally getting expired. So therefore, section 49 has to be used because the section 49 is without any look back period. If there is any transaction which is under section 45, an applicant make an effort that this application should also be covered under section 49. So Ankit, today we are discussing section 45 read with section 49. So first of all, we need to see what the provisions says, what exactly section 45 says, and who can find these transactions and can apply to adjudicating authority, means NCLT. Number one, a resolution professional or liquidator can file an application under section 45 subsection 1. And the most important part of this section is that even a creditor, even a shareholder and member of the company, even a partner of the company can file an application before the adjudicating authority, highlighting some of the transactions which are undervalued transactions. That application will be filed under section 47 subsection 1. However, the remedies available are the same. But then that's very, very important is that in case such application is filed by the creditor or a shareholder member or a partner of the corporate debtor, then in that case, it is not good for the resolution professional or the liquidator. Then the matter will automatically go to IBPI to find out why the liquidator, why the RP could not find these transactions. So for every RP or every liquidator, in case you find any transaction or in case there is any kind of forensic audit report available with the creditors, in that forensic audit report, if there are some transactions which are considered to be undervalued, that must be in your possession and in consideration while filing your application under section 45. We have already discussed in the last episode that application under section 45 has to be separate, application under section 43 has to be separate, and section 50 and also 66 has to be separate. Even we recommend at times that the application where under section 66 subsection 1 can be separate and under section 66 subsection 2 can be separate, because under section 66(1) we can also make third parties as respondents, and whereas under section 66(2) we cannot make third parties as respondents. That section 66(2) we only can make the suspended management as respondents. So therefore, when one has to be very, very careful that even I also recommend, based on my experience, in case you find any larger transaction, In case you find any larger transaction, that you can file a application right immediately after the constitution of committee of creditors in the case of CIR. In case you find, while you are taking control and custody, that the company's business has been handed over to another entity at a very, very low rent, you can always find it's a transaction. You don't need any avoidance transaction audit. You don't need any forensic audit. If you feel that there is a transaction, that entire business of the company has been handed over to another associate company at a very, very small rent, that you can always say that it is undervalued transaction, and you can file this application immediately after the constitution of committee, and after discussing with the committee of creditors, you can go for filing this application, and definitely you will get result, because this kind of result is important for even finding a resolution. In case you find, when you're taking control and custody, that some of the very important brands have been shifted to another associate concern, that application you must file immediately when you take over the company, so that the results are available in time, so that the recovery of the brand, or the recovery of the business back to the corporate debtor, should become part of the resolution plan, and the resolution applicant should consider all this as assets in the resolution plan. So that's very, very important experience that I'm sharing with you, that the applications can be filed immediately after even constitution of the committee of creditors, because the committee has to give some kind of clearance nowadays, not really for transaction applications, but of course we need to discuss with the committee that there is a substantial transaction. And I also recommend that for larger transactions, separate application should be filed, so that the pleadings does not take time. So in case, for example, there are 12 transaction applications. So there are 12 undervalued transactions. One is for the car, the other is for the office, the other is for a trademark. If everything is involved in one application, then it will take huge time. It will take a lot of time in completion of the pleadings. Somebody has filed the reply, somebody is not filed the reply, somebody has filed the rejoinder, somebody is not filed the rejoinder. That means that it takes a lot of time. So for any substantial value transactions, a separate application can be prepared, and you don't need any transaction audit for filing an application, because nowhere in the regulation, nowhere in the IBC, it is mentioned that appointment of transactional auditor or the forensic auditor is required. It is only a precedence. It is only that the structure of the IBC has been made in such a manner that not everyone is a chartered accountant. Anyone can become an insolvency professional. A company secretary, a lawyer, a cost accountant, a chartered accountant, a law advocate, a management expert. Everyone can become an insolvency professional. So not everyone can have the expertise of highlighting the transactions. Therefore, it has become a practice that the transactional auditor has to be appointed. But for filing an application under avoidance transactions, it is not really important that you should have an audit in your hand. This is something which is very important. Now, let us understand what is the look back period or relevant time under section 45. Like for a related party, the look back period is 2 years, and for an unrelated party, the look back period is 1 year. What are the transactions which are covered under section 45, subsection 2? 1. The corporate debtor makes a gift to a person. Now, let us try to understand a company or an LLP, how a gift can be made. The gifts are not made by the corporate debtors or companies or LLPs. The gifts are normally made out of love and affection by the individuals. But there are many transactions which can actually be considered as gift in case there is no value. In case there is a value taken, but there is a value which is significantly lower, that also is undervalued transaction. So gift means a transaction without any consideration. A transfer of an asset of the company, transfer of property of the company without any consideration. So that can be considered as a gift. Now, the other is, one condition is must for covering a transaction under section 45, and that condition is the transaction must involve transfer of one or more assets of the corporator. When we are saying assets, the word property is defined under section 3. We discussed in the last episode, episode number 120, in detail what is the definition of property. So under section 45 also, one of the property of the company must be transferred, and that property can be cash, money, bank balance, any asset with a with like kind of tangible or intangible, and also any kind of claims. So when we say claims, that means all receivables, all advances, or refunds, everything whichever is the claim of a company on another party, on another person. That claim is also an asset of the company. If I assign a debtor, if I assign a receivable to some creditor, that if that means transfer, that is a transfer. If I'm actually assigning a kind of litigation result to a related party, if I'm assigning a arbitration litigation to a related party, and I'm saying along in an assignment agreement that I have handed over this total litigation, and whatever would be the result out of this arbitration dispute, that will go to my associate concern, and I have taken a consideration. That can be an undervalued transaction. That can be undervalued transaction. So the consideration can be zero, and the consideration can be significantly less than the value of the consideration. Now, such transaction should not have taken place in the ordinary course of business. Now, what is ordinary course of business? That we have already discussed in the last episode, episode number 120. We discussed what is the ordinary course of business. So in case we see that this is ordinary course of business, then the most of the respondents will say that this transaction has taken place in the ordinary course of business. Like in some of my cases, the stock is transferred to the suppliers. The stock is transferred to the supplier by saying that we have returned the purchase. So we found that one, it is a creditor, and the property of the company has been transferred to a creditor, antecedent creditor, old creditor, that is not in the ordinary course of business, because that creditor otherwise should have filed their claim. So we have returned the goods to them. So that means that we have we have transferred the assets of the company to a person who is not entitled to under section 53. The priority is much lower. So that also gets covered under section 43. And in case while transferring, I transfer it at a price which is lesser than the price of market value, that also becomes undervalued transaction. So a transaction can become under section 43 also it can be covered, and under section 45 also it can be covered, read with section 49. And some of the transactions are covered in all the three. Section 43, 45, and 66, some of the transactions can be covered in all the three. Now, in this particular section, 46 subsection 2 also says that the adjudicating authority has a right to get an independent expert for the value of the transaction. So in case the application has to be filed with and to avoid any delay. So in case we are trying to say that there is a transfer of an asset and the consideration has been received, there must be a kind of rationale for saying what is the value of that asset. Either there is a valuation report or there is any other belief, maybe the purchase price, maybe the depreciated value in the books of account, and maybe any other assessment of the value, like in case we sell car. So there are many kind of websites available where you can get the value of the car assessed, and you can take out 1, 2, 3 printouts saying that this is the value of the car when I entered the model, the year, and the year of manufacturing. So the value, this is the value which has come, and also the value which is received is much lesser. So very importantly, the beneficial transferees has to be made respondent. Beneficial transferees had to be made respondents. That is very, very important. Now, when we file these applications, what kind of orders can be given by the adjudicating authority? One, that this transaction of transfer of asset can be held as void, and the adjudicating authority can pass an order to reverse the effect of such transaction. Second kind of order is they require any property transferred as part of the transaction to be vested. Any of the property which is transferred, the order can actually say that this property is vested back to the corporate debtor. Now, if there is any security interest which has been created, for example, a security interest has been created after I have taken a loan, say loan of ₹2, and I have given a security of 10. So that also security can be considered as released, because that also considered as a kind of a security interest, even if it is transferred or even if it is mortgaged. Then we can even the NCLT can also order a person to pay a sum of rupees this much to the to the liquidator or to the resolution professional, or there are orders which are possible require the payment of such consideration for the transaction as may be determined by an independent expert. So in case there is a property which is transferred for 10 lakhs and the valuer say that the property is having a value of 20 lakhs, so the NCLT can order that the buyer, the beneficial transferees, can pay rupees 10 lakhs to the liquidator or to the RP, and that is something which is the part of the orders. Now, when we see the under section 47 subsection 2, it is very clearly written that in case the RP or the liquidator has not reported a transaction, then the application under section 47(1) can be submitted by any creditor, any shareholder, or any partner of the company. And as per the orders are concerned, the orders will be fine. Then the NCLT will also require the IBBI to initiate disciplinary proceedings against the liquidator or the RP. This is mentioned in the section 47. That is very careful. That let us be very careful that these undervalued transactions are likely to be reported. It can be reported by anyone, and therefore the disciplinary proceedings will be started against the liquidator. Now, while passing the orders against the beneficiaries, the adjudicating authority will protect the persons acting in good faith, and the interest in the property is protected, and their interest in the property is protected. Now, it is very clearly mentioned that if an asset is acquired from a person other than corporate debtor and was acquired in good faith for a value and without notice of relevant circumstances. So what are the components for protection? One, that the asset is not acquired from the CD, asset is acquired from third party. That third party might have acquired it from the CD at undervalued. Then the buyer of that asset has acted in good faith. Then he has paid the value for that asset, and he has no notice of such circumstances, such knowledge that he has acquired an undervalued transaction asset. That person would be protected. That person cannot be asked to give the property back. That person cannot be asked to vest the property back into the corporate debtor, and would not also be told to deposit the balance consideration. Now, it is also one protection is also available in this action. That is one protection that a person shall not require a person, the adjudicating authority shall not require a person who received a benefit from the transaction unless he is a party to the transaction to pay a sum. That person must be a party to the transaction. In case that person is not a party to the transaction, the the adjudicating authority shall not require that person to pay some amount to the corporate debt. The only conditions are that the transaction is in good faith. He has paid the value and he did not have the understanding of the insolvency of the company. Now we have to see what are the transactions which can be covered under Section 49. So the heading itself says that the undervalued transactions defrauding creditors under Section 49. For bringing a transaction under Section 49, first threshold that we have to cross, which is mandatory threshold, that the transaction must be covered under Section 45, subsection 2. In case we cross that threshold, that means what is the threshold? That there must be transfer of a property of the corporate debtor, or there should be a gift to any other person, and whatever transaction has happened, that transaction have happened at a value which is much lesser than the value of that asset. So this is the threshold. So in case we don't cross this threshold, then we cannot land under the Section 49. Now, what additionally we have to prove to bring a transaction under Section 49? What additionally? So we have to say that this transaction was entered into with the objective of keeping the assets of the corporate debtor beyond the reach of creditors. The asset was transferred so that the creditors or the RP or the liquidator cannot take control and custody. The asset was transferred so that the value of the assets left for the creditor is reduced. And it also adversely affects the total assets of the corporate debtor, and it adversely affects the interest of the creditors. To my mind, most of these transfers, like the transfer of car, transfer of good office, transfer of good property, transfer of some of the good receivables, for each such transfer, the objective is very clear, that the suspended management wanted to keep these assets beyond the reach of creditors. They wanted to reduce the value of the assets which is available for the creditors. They wanted all these assets not to go to the control and custody of the RP or the liquidator. And it is adversely affecting the interest of the creditor. So in most of the transactions, we can cover that the Section 45, subsection 2, read with Section 49. What is the benefit of covering a transaction under Section 49? Then, in that case, the look-back period is not applicable. Even if that transaction has taken place 7 years back, even if the transaction has taken place 5 years back, the transaction cannot be covered under the beyond the look-back period. Adjudicating authority in such cases can pass an order restoring the position as it existed before such transaction. Asset can be vested back, the transfer can be held as void, the trademark which might have been transferred to other persons, that actually can be considered as void, and as if this transaction had not happened. And by doing so, the adjudicating authority will protect the interest of the creditors who are victims of such transaction, Again, I would say the protection of a person who have acquired these under good value. So this is very clear, I would say, in the case of Vittal S.A. Abhishek Nagori liquidator versus Asian Natural Resources India Limited. This was held by NCLT in Indore bench, and later on it was confirmed by NCLT also in various other orders, that the look-back period for undervalued transactions, which are covered under Section 49 also, no look-back period is there. No limitation period. For fraudulent transaction under Section 49 or something like that. Some of the applications that we have prepared for sale of very, very expensive and new and fancy cars from the corporate debtor to some individuals or some other companies. So in such cases, the valuation of the car is very important. The WDV of the car is very important. The year of purchase is very important. In some of the cases that we saw, that the cars were transferred from the books of account by way of journal entries, by way of debiting to some of the creditors or some of the directors' loan account. However, no evidence was provided about the date of such transfer. The registration certificates were not provided, RC was not provided. The website of Government of India regarding vehicles, that was showing that the cars are still in the name of corporate debtor, or the cars were transferred within the look back period. So the court held that it is the duty of the suspended management to prove that a transaction is beyond the look back period. In case they are not able to provide any evidence, then it will be considered within the look back period. Similarly, sale of any good office or good property of the company before, because they never wanted to, the suspended management never wanted that it should come under the control and custody of the RP liquidator creditors, sold to a related party. There also the valuation is important. The circle rate is not only the one evidence, the valuation has to be obtained for such transactions. Giving loans and advances to unrelated parties without any business objective, that also would be covered under Section 49, because the amount has been transferred. Funds have been transferred, that a property has been transferred. The consideration has been nothing. There is no consideration, there is no business association, but the money has been transferred simply. And that can be covered under Section 49, because the objective of the transaction is to keep that asset away from the creditors, beyond the reach of the creditors. Transfer of trademark to franchises, transferring franchises to another company, transferring shares of the subsidiary companies, having some lucrative business to other companies, to other individuals, transfer of trademark, brand, copyrights to other things, transferring intellectual property rights which are usable, which actually can be considered as some kind of developing new businesses. So Ankit, at this moment, I would like to see what kind of questions are there, or we can see what kind of questions the participants would like to ask. We will exactly take 10 minutes for this part, and then we will spend 20 minutes on the various judgments.
So, so basically, the questions that I have, like Hari Prasad ji is asking that in undervalued transactions, if asset is transferred by the CD to a first party at a low value, and the first party in turn transfers that asset to a second party at a higher value, can RP seek a relief or to direct the first party to return the difference of price between the price he had acquired the property and the disposed price of the property? So this is what
Certainly,
he's
yes,
asking.
certainly. One,
Yeah.
that it is a huge, it's a very, very kind of good evidence that you transferred a property to A for 10 rupees, and the A sold that property to B for 20 rupees. Now, so that means the value of the property is 20 rupees, and it has been transferred by the company at 10 rupees. So therefore, the difference is at least 10 rupees. However, the RP or the liquidator can also see what is the value of the transaction. In case there may be a possibility that the asset is transferred at 20 rupees, but beyond also there is something which has been transferred in cash. So the RP must see the valuation and should not restrict only on the gap between A and B. The valuation is important. Valuation may be 30 rupees and the transaction is only at 10 rupees. So there may be a possibility of recovering 20 rupees from the beneficial or transfer.
Right. So other than this, we have a question that is ignorance of law, can it hold good for a beneficial owner? So there again,
There are judgments. Like in case there is a public announcement about the insolvency of a company, and that public announcement can be considered as the public has the knowledge at large. But in case there is no public announcement of the insolvency of the company, then we have to see the circumstances, whether the person knew about the insolvency or not. Ignorance of the law cannot be considered as the good faith. The good faith is that the transaction is in ordinary course of business. It was done in good faith. The proper value was paid. These are the arguments that can be taken by the respondents. But simply saying that I had no knowledge of law would not be accepted.
Right. So apart from this, then we have Mr. Lalit Maheshwari, who is asking that when CD donated to political party 2 crores to gain the benefit from political party, whether this transaction will be considered as puff transaction. It can be considered as a Section 66 application where you're using the funds in a fraudulent manner. That's
No, see, the
like,
question is the
because
giving money.
there is a possibility that one is taking a loan from the bank and then violating the sanction letter by using the money to pay to a political party. So that would be the allegation here.
So in this case, we also have to see whether the transaction has taken place during the twilight period. Now, the twilight period we actually have explained in our episode number 120, where we have said that the twilight period typically is that particular period when the sun is set, but still there is some light on the earth. So that period when everyone is very sure that after some time there will be complete dark. So the transactions which takes place during that period when there is a belief that there is going to be a dark, but still there is a light, still you can do some transactions. So transactions done during that period, that is something which is considered to be violent, considered to be violating the sections, maybe 43, 45, and even 66. For section 66, for considering a transaction under section 66, and specifically section 66, 1 and 2, the twilight period, twilight zone is very important. So therefore, if this donation has been given during the twilight zone, that actually means that the group has other companies and they wanted that the asset of this company should be reduced, and so therefore they transferred this asset to a political party with the objective of keeping it away from the creditors and beyond the reach of the creditors. So this can be a transaction which can be a gift under section 45 subsection 2, and it can be recovered from the political party, or it can even be recovered from the suspended management who have taken this transaction.
Right. Then we have a question with respect to what if, in case of real estate cases, mortgage units are sold by CD without NOC of the lenders? Is that covered under Section 66? That's a question from Mr. Sandeep Mahajan.
No, that is not a transaction which can be considered as fraudulent or undervalued. The units were mortgaged to a bank, and the units were sold by the suspended management to other parties at a value. If that value is appropriate and the money has come to the books of the corporate debtor, that is not something which can be covered in any of these sections. The bank can always say that it is a fraud. The bank can say it is a fraud based on their terms and conditions of the loan. But this transaction is not covered under section 43 because there is no preference to any creditor. There is no undervaluation because the asset of the company has been transferred at an appropriate price. There is no gift. So there is no fraudulent intent because see first of all, the asset has been transferred, but a consideration has come to the corporate. Now, saying that this can be covered under section 49 because this transaction has been done to keep that asset beyond the reach of the creditors. What I understand is, if it is a standalone transaction, the buyer can also be engaged in the litigation. The bank can always say to a court that the asset which was mortgaged to me has been transferred fraudulently, and the buyer also cannot have the buyer also cannot have the proper title of that property because that property is already mortgaged to someone. So if the mortgage is prior, the buyer will not get the title. So that's what I am saying. So this transaction actually has the impact of Transfer of Property Act because the mortgage was before and the transfer was later. So therefore, the later transfer would be defective transfer.
Right. So then we have a question which talks about property purchased during the look back period from CD at full value. Can that transfer be set aside? So here again, if the property is transferred at circle rate or more, and one cannot establish that there is an undervalued aspect to it, it would be difficult to challenge it. However, in such cases where this kind of property has been sold, when we do forensic audits, we always look into the possibility that the money that has come in might have been diverted to some other use rather than payment to the creditors. So that is something that we look for. Maybe the money has gone back to the directors, maybe it has been used to make payment to other creditors. So these are possibilities there. Then we have 135 days limit. So can application or filing one application beyond 2 years, is it feasible? So in case the transaction audits are getting concluded at a later date and one can establish that the delay was normal, or rather the delay was because of the lack of information of the from the suspended directors and other valid reasons, then that delay I don't think can be a problem.
NCLT has held in a case that all these timelines provided in the regulation, these are directory. In case of delay, that does not take away the right of the RP or the liquidator to file applications. However, why the delay has happened, that is something which is a regulatory issue, and IBBI will handle that, not the NCLT. And the benefit of such delay cannot be passed on to the offenders.
Right. Then we have a question that it is learned that outcome of forensic audit report has not got so much appreciation by NCLT, whether forensic accounting standards issued by ICI can improve it. So we have reviewed or we have understood the forensic accounting standards per se, the standards with respect to how the report should be made and what all should be covered. But then each and every transaction audit is very different, and what is important is that the conclusion that a transaction auditor derives in this report, it should be conclusive, it should be based on data, it should be based on concrete evidence. That is the important part. So it actually is more about the practice or the practicing professional rather than the standards, is what my feeling is.
Yes.
How to make recovery and file prosecution after avoidance transaction order by NCLT. So in my case, NCLT allowed my application. Now I am not able to find the system to make the recovery against the suspended director. This is from Mr. Tarun Batra.
So, Mr. Batra, we have a judgment which is from either, I believe, from Bangalore or Chennai bench, which says that the NCLT has the jurisdiction of execution of an order. Executing recovery is within the jurisdiction of NCLT. So RP will have to find out by just appointing some investigating agency about the assets of the respondents against whom the orders have been passed. Once the RP finds those assets, immediately an application can be submitted to NCLT for attachment of those assets. And then the NCLT can even pass an order giving powers to the RP or the liquidator to sell those assets and recover this money. So the powers of executing such recoveries is also within the NCLT.
Right. So, please highlight how RP or liquidator can ensure that audit report is conclusive in nature and not merely based on assumption.
No,
By
I don't
providing
think
more
that
information.
no, Ankit, I have an opinion on this. I am sure that the role of the auditor is to highlight a transaction
Hmm.
with evidences, determination, and filing of the application. That is the job of the RP or the liquidator. It is not really important that the transactional auditor should say that this transaction falls under section 43 or 45 or 49 or 66. It is not important. The transactional auditor has to highlight a transaction. According to him, the transactional auditor may say that the transaction falls into section 43, but the RP can take a decision whether the transaction falls into 43, 45 or other. So therefore, the transactional auditor is not a authority to decide about a transaction, decide about a section under which it falls, and whether to file an application for this or not. His job is only to highlight a transaction after looking into the books of account and other bank statements and other uh, records. Because he is expert in understanding the books of accounts and also transactions, but that determination would be totally depending upon the RP or the liquidator.
Right. I think that's about it. We can continue.
So I think we can look into various other kind of undervalued transactions. Like I also see in some of our cases the purchase of any asset at a very high value. Now I have seen that the promoters know that there is a dead company in the group, and there is for example, there are 10 crore rupees lying in this company. So they will say that we have purchased the shares of that dead company so that this money gets transferred to the some of the family members or some of the associate concerns, and a dead asset comes to the uh, balance sheet of the corporate debtor. In this case, we have to say that this asset which has been acquired at a very high value, that is also a kind of undervalued transaction with section 49, because see the it's a kind of gift that I have taken a value of rupees 2 and I have given 10. So the balance 8 rupees is a kind of a tantamount to gift. Similarly, settlement of the dues of the associate concerns or even other parties at a value which is much less than the due amount. That can also be considered assignment of a debt asset. Assignment of an asset is also transfer of a property under section 45. If the value is less than the actual value, that will also be undervalued. Writing of sundry debtors, not recovering sundry debtors, giving advances without justification and without any reason, and no effort to collect money, that also can be considered as a gift under section 45. Although there are one or two benches in Mumbai, they are saying that if the money is shown recoverable in the balance sheet, how can it be considered as gift? But in case the money has been given to someone without any reason, without any consideration, and without any justification, that means that the only objective of such transfer is to keep that asset beyond the reach of the creditors. So it very well gets covered under section 49. So that can be covered under section 49 so that it can be recovered. Because see, there is a confusion whether the third parties can be involved under section 66 or not. Whereas the section very clearly says that under section 66(1), the third parties also can be covered. However, under section 66(2), only the suspended management can be covered as respondent or can be covered as the contributories. Whereas under section 66 subsection 1, even the third parties also can be covered as contributories. So as I said, the sale of unsold inventory by real estate company before CIRP at a price which is much less than the market. All these are the transactions of undervaluation. Now, I'm trying to see like what are the transactions which are actually can be covered. Let us see what kind of judgments that we find under section 45 and 49. So we will just come to some of the judgments, starting with of course, Anuj Jain. That's a very, very popular judgment. In that particular judgment, the uh, Honorable Supreme Court has highlighted what exactly can be the undervalued transactions. Those undervalued transactions, which are in the case of JP Infra, the Supreme Court has actually observation in the case of Anuj Jain, the interim resolution professional for JP Infratech versus Axis Bank Limited. That judgment is dated 26th February 2020, and most of the judiciary is using this judgment. Now, they're saying that the undervalued transactions occur when a corporate transfer assets for significantly less than their value. Determining significantly less is complex and context dependent. So significantly less would be depending on the context that we are talking about. Avoidance under section 45 requires proving the transaction was not conducted in good faith and outside ordinary course of business. Now, in this case, the NCLT noted that for a transaction to be considered undervalued under section 45, the RP or the liquidator need to examine transactions made during the relevant period to determine if they were undervalued, especially if a transaction is considered undervalued if the corporate debtor makes a gift or transfer assets for a consideration significantly less than the value of the consideration provided. But in this particular case, in the case of JP Infra, the mortgages that was created, the Supreme Court held that these creation of mortgages did not fall under the criteria for being considered undervalued under section 45. Now, what exactly was said by Supreme Court? The mortgages in question, which were made in favor of the appellate banks and financial institutions, have been made in ordinary course of business and financial affairs of the transferee, as apparent from the relevant. Now, in one of the case, which is decided by NCLAT very recently on 25th of January 2024, the title of the case is Gloucester Cables Limited versus Fort Gloucester Industries Limited. Looks like related parties, and this judgment came from NCLAT in January 2024. Now, this transaction involved the assignment and hypothecation of a trademark called Gloucester that was owned by the corporate debtor, and it entered into a supplemental trade agreement with Fort Gloucester Industries. The only thing which was like important in this case was that the trademark was this particular uh, uh, agreement was entered in July 2008. July 2008. That means much before than even the insolvency law came in light. It was transferred for 10 lakhs of rupees. And so this transaction, when we see the facts, finally the issue was one issue was very important: whether NCLT has jurisdiction to decide on the title of the trademark, whether the assignment of the trademark to the appellant constitute an undervalued transactions or not. As far as the jurisdiction is concerned, NCLAT held that NCLT has jurisdiction under section 60, subsection 5, clause C of the IBC to decide on matters related to the insolvency resolution of the corporate debtor, including disputes over assets like trademarks. The validity of the trademark assignment agreement was held as valid because it was basically entered into to make the BIFR scheme effective. So therefore, it was not held as undervalued, but it was clearly held that such disputes are under the jurisdiction of NCLT. Another judgment is from NCLT New Delhi Bench Court 2, and the name of the judgment is Subhash Kumar Kundra. RP of the Classic Bottle Caps Private Limited versus Shiv Seth. The judgment is dated 21st of August 2023, and in this case, the company entered into an unstamped and unsigned memorandum of understanding, MOU, and by way of that MOU, the raw material was supposed to be supplied and the payment was supposed to be given in the bank account. of the corporate debt. However, the amount was not given in the bank account of the corporate debtor. It was given in the personal accounts of the promoters. That particular transaction was reported, and it was held that it is a transaction covered under Section 45. The job work revenue is transferred to the suspended management's bank account. That is a receivable, and that's an asset. It has been transferred to the account of the suspended management, so it is likely to be recovered. And also, there was comment that this transaction also should be covered as fraudulent transaction. Another judgment by NCLT Mumbai in the case of Saurabh Kumar Tikkamani versus Talwal, Talwalkars, Talwalkars Club System Private Limited. You might have seen Talwalkars were a lot of their gym organization, which set up a lot of gyms. Now, in this company, the RP identified that there are too many interest-free advances given by the company to rated parties. To take away the money which is available in the company, to take away all those assets, it was given as interest-free advances to related parties. The RP says that I want to claim 12% notional loss to the company, 12% interest per annum. Now, the fact is that the loan were given and no interest was provided. So RP says that in the audit report also, this was said that these transactions are undervalued transaction. So what finally the court held? In fact, the court finally said that it is an undisputed fact that the money advanced to a related party is recoverable from them, irrespective of the fact whether they are undervalued transactions or not. Accordingly, this bench is of the view that these amounts, still being the property of the corporate debtor receivable, those transactions cannot be held to have resulted in a transfer of any asset if it is shown as recoverable. Therefore, this bench feels that this is not an undervalued transaction. So therefore, as far as the notional interest is concerned, the granting loan without stipulation of interest thereon per se cannot be said to be resulting into undervalued transaction. There can be various considerations for granting loan to associate concerns without interest. So therefore, the bench says, however, the bench finds that Section 66 of the code provides that if the business of the corporate debtor has been carried on for any fraudulent purposes, the person who are knowingly parties to such purpose can be made liable to make contribution to the assets of the corporate debtor. I'm not sure whether the liberty was provided to RP to file a fresh application under Section 66 or not, but primarily the NCLT says that if an amount is shown as recoverable in books of account, then RP should make efforts to recover that amount. In case, however, in such cases, my experience is that whenever you say that it was transferred to some people, then we also must see whether that amount is recoverable or not, whether those parties' KYC are proper or not, whether those parties' financial position is okay or not. Because in one of the cases, the entire stock of the company worth 800 crore was sold to 4 persons who were basically the proxy of the promoters only. Those were individuals, those were their peons and drivers, and 200 crores of stocks was sold to these 4 individuals per individual. So total transactions were 800 crores. The bench says that this amount is shown as recoverable from these. So we highlighted that these 4 people, they are the people who are living in Chawls. They are not having any address. Their KYC is disputed. So this is only a fraudulent transaction. But the court says that if the money is shown as recoverable, we have filed an appeal before NCLAT, and we are expecting a good result, because in case we are able to show that the auditor 1 has said that these parties are fake, auditor 2 have said that these parties are not having any permanent address. Some auditor have even investigated and went to the offices mentioned. There was nothing in those offices. If the promoters are giving 200 crore credit to such people without getting any recovery, without getting even one payment, the entire stock was sold, I believe definitely the appellate authority will give us justice, and the creditors will get some kind of order which is good uh, for them. Another order that we can see is the NCLT Chennai G.V. Ravi Kumar liquidator versus K. Kuppuswamy. This judgment is little old, but this judgment this judgment is 9th of June 2021, but it involves a transaction with some undervalued transactions like transfer of company properties and asset at significantly lower than the market value, assignment of receivables and other key assets without adequate consideration. So these two were held to be transactions, and the appropriate order was passed by NCLT. So this order can also be considered as good order. Now the other order is that we can see is the NCL80. NCL80 in the case of Technico Industries Limited versus Debashish Nanda liquidator of JV Strips. The corporate debtor is JV Strips Limited, and in the case of this, the discounts were given, processing costs were also added, and the concerning poor quality. Now, suppose I have a receivable of 100 rupees in my books of account, and a year before the CIRP, within the look back period, there is a settlement where a lot of discount is given based on the some kind of delay, processing cost, and also concerning poor quality. And it was held that it was a normal course of business. Such kind of deductions are ordinary course of business. There are evidences, there are documents to show that the total recoverable of rupees 10 has been reduced to 5 because of such discounts and damages and processing cost, etc. Even NCLAT also upheld the decision in such cases. The sale of premises or units by a real estate entity, that is also shown as ordinary course of business in the case of Rajiv Manadiyar versus Gopal Dalvi. So that is also a judgment from NCLT Mumbai. So these are the transactions where the sale agreement submitted by the respondent and the limited records are available with the corporate debtor for the various several discrepancies noticed. So this also transaction, then it was considered that this transaction was in the ordinary course of business. This was not held as undervalued transactions. Ankit, we can take up some of the questions, although I have lot many judgments, and we are presently, today we are at Rewa, and we are here to take over control and custody of one of the unit of JP Cement, because see that JP Cement is now one of my partner, Deepika Prasad. She has been appointed as the IRP. So we have come to this place, Rewa, to take control and custody of the unit. So we have to move. So we have to see, Ankit, we can take up some of the questions in case there are any. So I can even see that there are some people, they wanted to say something. Mehraj Kumar, in case you want to say something.
Good afternoon, sir.
Yes, please.
Yeah, sir, actually, we have been talking about how to have the transaction audit report to substantiate and make your case stronger before the Honorable NCLT in order to justify that, okay, that application, is considered. So, there has been tussle going on between the RP and the auditor, on the report, RP has got a different kind of view, whereas the auditor, is not giving the concise and report which could stand the test of law. So, how to, sir, deal with this kind of situation?
No, my understanding is that this is not the duty of the auditor to give us a conclusive report. The auditor should say that these are the evidences and I am highlighting these transactions. It is the duty of the RP and the legal experts of the RP to find out whether this transaction falls under section 43, 45, 49, 66. So the duty of the auditor is only to highlight those transactions after verification of the books of accounts, bank statements, and other records. The determination of exact section is the duty of the RP and the legal team of the RP. The only thing that we must assure that whenever a transaction is reported by the auditor, he should not have a kind of disclaimer on that transaction.
Yes.
He should not say that I could half verify that. He should say that I have verified, and according to me, this is the transaction. So he should not say that I could not verify this part of the transaction, or I could not verify this part of the transaction. He has to say very cleanly that this is the transaction. So that kind of disclaimer are not required. However, the section and the nature of transaction, it is the duty of the RP and the liquidator to determine and finally file an application.
So can I get it changed based on my information and concrete evidence that it must be recorded in the report, sir?
So that is not important. In case that complete evidences are not part of the report, then the RP or the liquidator can attach those evidences before the adjudicating authority, and the adjudicating authority will never be able to say that this was not part of the audit report. These are the evidences that we have collected independently. These are the evidences which say that this transaction is a avoidance transaction. That itself is sufficient. It is not important that the transaction should appear even in the audit report. What I said at the beginning of this episode, that some of the transactions that you find while taking the control and custody. For example, if you find that the entire unit having a cost of 300 crore is given to an associate concern at 30 or at 20 lakh rupee rent per month, then you can immediately file an application to adjudicating authority that this is an undervalued transaction without waiting for any transaction or auditor. Immediately after the constitution of committee, you can always file this application. That is what I am saying. The auditor's report is not required for reporting a transaction to NCLT.
Sir, I am well within the right to ask the auditor to remove those kind of disclaimers.
No, you have the right, but then accordingly you have to say that if the transaction if the evidences are not available with the auditor, then he will say that way. Then it becomes the duty of the RP or the liquidator to provide those evidences. Otherwise, he will say that I have only verified half the transaction. So I believe we have the constraint of time. Some people are waiting for me, so maybe that we have to close this webinar. Thank you very much. And
thank you so much, sir.
As we always say, that this is our way of learning. Thank you very much. Thanks a lot.